Kevin, today we're here to discuss Clarence Thomas and the recent revelations that he has falsified 20 years of financial disclosure forms. Can you talk about that and tell us the importance of this?
Yeah, well, first off, this goes back to when his nomination was being considered. So right from the beginning, the Senate did not know the full story about his family income. And so right from the start, that's a problem. But the other thing about this is not a complicated process. I have the forms right in front of me here. And the section that is involved here is very clearly says spouse's non-investment income. It's essentially, what kind of income does your spouse have? Very simple question. And they just ask one line, what's the date of the income, and what's the source and type of the income? Simple question, not complicated at all, a very easy form. And the other thing about this form is it makes it very clear at the end, any individual who knowingly and willfully falsifies or fails to file the report may be subject to civil and criminal sanctions, and they give the citation to the law. So it's not a complicated form. It's very clear this is an important form because it talks about criminal and civil sanctions. And for a Supreme Court justice who deals with all sorts of complicated statutory interpretation, not to understand this is hard to accept on its face. I can't believe that he's not smart enough to understand this form, especially when, as a Supreme Court justice, he's actually ruled in cases against people who have failed to file these forms properly and who have been prosecuted criminally and sent to jail. And it's an important form for a number of reasons, not just because the public has a right to know this, but because litigants who go before the Supreme Court need to know potential conflicts of interests. So they can ask the justice to recuse themselves, so they can fashion their argument so that it fits with those concerns. And so litigants who've been before the court have not been told that kind of information. They've been denied that kind of information. For example, it would have been interesting to find and unfortunately they don't provide this information now. This is so old. Back in the Bush v. Gore era, that was a 5-4 decision that decided the outcome of the presidential race. A year later, when all the votes were counted in Florida, Vice President Gore actually got more votes than President Bush got. But the Supreme Court stopped the counting of the vote. They didn't order a recount of the whole state. 5-4 decision. During that time period, his wife was collecting resumes for the Bush administration. Now, if he had filed this form, we would have known that she was working for the Bush administration's transition team. And even just knowing that she was doing that was enough reason for him to recuse himself from that critically important decision, that 5-4 decision. And him not being able to be on that panel would have changed the outcome of that case. Now, this has happened again more recently in the very important Citizens United decision. Citizens United was the case that opened the floodgates to corporate money and mass amounts of individual money into elections. It took all the limits off where corporations can spend as much as they want to influence the outcome of the elections. In independent campaigns, they could say, vote for so-and-so, don't vote for so-and-so. Now, at that time, according to the newly filed forms, Justice Thomas's wife was working for the Heritage Foundation. This is a conservative activist think tank that certainly gets involved in presidential elections and in trying to influence the outcome of elections. Shortly after Citizens United, she formed her own organization that spent hundreds of thousands of dollars trying to influence the outcome of elections. So she benefited financially from the Citizens United decision. So for all these kinds of reasons, we want to see Justice Thomas brought to justice. One of the things that you see as a problem in around the world and in the United States is special treatment for special people. We are a nation of laws where everybody's equal before the law. And people have been prosecuted for failing to file these forms correctly. Justice Thomas should not get a free ride. Just because he's a Supreme Court justice does not mean he's not subject to the law. In fact, it should mean the opposite. It should mean that people expect him to obey the law, that he's smart enough to understand the law. And so he should actually be investigated for this and fined or criminally prosecuted as the law requires. He should not get a pass. And so we're seeking we're taking several steps. First, we're seeking from the House of Representatives impeachment. That's essentially a prosecution by the House, and then the Senate will sit in judgment if they go that far. The first stage in the House is essentially like a grand jury seeking an indictment, and then there'll be a trial in the Senate. Second, we're seeking the Department of Justice to enforce the law. Equal justice before the law is the motto on the Supreme Court building. Let's apply it. And then finally, we're going to be filing with the Bar Association in Washington, D.C., seeking to have his bar license revoked for 20 years of violations of this important law. So we want to see accountability. We want to see equal justice for the law, and I think Justice Thomas should also want to see equal justice for the law and should really voluntarily take action to correct this error.